America, the state of Tennessee, and this honorable court.
Good morning. Before we call the case, I just want to go over a couple of things with the attorneys here. We understand technology is not always infallible, so if we have any problem on anybody's end, we'll work through it. Just if you do something, I'm sure Mr. Hibner's already told you to notify him if you have any problems. And we understand that sometimes things happen, and we'll just deal with that as it goes. Appreciate you being here this morning. Mr. Hibner, call the case, please.
In re Jackson D.
We'll hear from the appellant.
Thank you, Your Honor. My name's Eric Armstrong from the Bradley County Bar, and I represent the appellant in this case. I'm requesting 5 minutes of rebuttal time.
Yes.
In our appeal, Your Honor, this case was tried last year, over a year ago, actually, and what with pandemic issues and everything, that certainly did play a role in the case's delay getting to the Court of Appeals. But the issue that we raised on appeal had to do with whether the trial court properly found that it was in the best interest of the child to have the parents' rights terminated. The original petition was filed, I think, on a couple of grounds, if I remember correctly. Primarily, counsel at trial, if I remember correctly, decided to try the case with respect to 2 felony convictions that my client had that we aren't disputing with respect to the fact that those convictions did occur. And we haven't raised the fact that grounds were met on appeal. We're simply raising the issue of the best interest in the case. And Your Honors, the reason that we contend that it wasn't in the best interest of this particular child to have the parents' rights terminated chiefly revolves around the extent to which this father had a relationship with his child at the time that he was placed in custody. At trial, he testified to the fact that he had a very close relationship with his son, who was, I believe, around 6 years of age at the time these events occurred that my client was convicted of. For the court's edification, I will tell the court that the convictions were, one was a conviction for computer pornography, and the other one was for sexual relations with a 17-year-old student. He was a teacher and had been teaching for 4 years. He went into custody, and at the time of the trial of this case, he was, one of those convictions was in North Carolina and the other was in Georgia. The Georgia conviction was where he was spending his time. And when we tried our case, he appeared via telephone, and he testified by and large to the fact that before he went into custody, he and his son had a very close relationship. He testified that he was very much involved in the child's upbringing, and that as a result of that, he had a very, very close relationship with his son. After he did go into custody, both parties were living in Georgia at this time. He did testify that the mother did bring the child to visit with him when he was in custody there. And the child also got to visit by Skype. I think the mother made the decision to not bring him to the jail every so often because she was concerned about the impact that it was having on the child. Eventually, though, the mother just decided to cut off all contact whatsoever. And so my client, in an effort to maintain some semblance of a relationship, what he did was wrote letters and attempted to compile these letters with the help of his mother to give to his son someday when he gets out. He deeply cares about and loves his son, and very much is concerned about having his parental rights terminated, to the point that when he received this petition, he actually contacted Mr. and Miss Moss and wrote them a letter imploring them, asking them to please withdraw their petition, and telling them he felt like it was in the letter in so many words. He asked them that he just wanted to be a part of the child's life. He didn't want to have his parental rights terminated. My recollection is that the adopting father, the petitioning adopting father, testified that he did not perceive this letter as a threat in any way. It was just a letter that where he was essentially asking or soliciting the petitioners to drop their petition. Of course, they didn't do that. But he also testified at great length to the fact that he was very much involved with those other inmates and that he attempted to rehabilitate and continue to rehabilitate his own self while he was in custody. And he also testified to the fact that he was involved in the GED program at the prison. Him being a person with a college degree, he was a teacher, gave him, I guess you would say, the bona fides to do that sort of thing. And he was also involved with pastoring and also mentoring other inmates there as well. He testified that it was something that he did in order to rehabilitate himself as much as anything else, because he wanted to maintain and to tamp down the chances of any kind of recidivism ever happening in the future, and wanted to completely and totally rehabilitate himself as well. That was also part of his motivation. He very much, and I understand when the court is reviewing cases like this, when you're trying to analyze the question of whether it's in the best interest, of course, we look at 3611-113, and you have that list of factors that we look at. And then at the end, of course, we can look at other factors as well, in addition to those 9 that are laid out before us. But the one that I rely upon that favors, or the ones that I believe that are most favorable to him in this particular situation, would be number 4, which speaks about the meaningful relationship that has otherwise been established between the parent and the child. That is one. It was, and again, as the court probably already knows anyway, these factors aren't necessarily weighed equally or one more than the other. The court just needs to look at all of them in determining whether these factors apply in a particular case and how they apply.
So,
and go ahead. I'm sorry.
When you look at the meaningful relationship, what do you have to say? And I understand it makes record proof about the effect that this continuous contact that he has with this child, the effect of that contact on the child as to the child responds, the things that the child was doing as a result of that. Well,
the mother did. I'm sorry, I didn't mean to interrupt anybody.
That's okay. Go right ahead.
I do recall the mother testifying that she made the judgment to stop the trips back and forth and the contact by Skype, because she claimed that the child was reacting adversely to that, wetting the bed and things like that, if I remember correctly from the testimony. And this was uncontradicted. My client has no way of knowing whether that's true or not. We accept the fact that the mother did testify to those things, because there's really no way we can check that. And again, those are things that are very much, I have to admit, Your Honor, that those are things that you have to account for when you're trying to decide whether the relationship should continue or not. I believe, though, that the greater weight of the evidence would support allowing, since my client has never contended that Mr. and Miss Moss are bad people. In fact, in the letter, he was very much supportive of them. He wanted to try and raise the child or be a part of the child's life as a team with them, is the way in which he addressed it. And that's the approach that he was taking. So, but with respect to your question, your direct question about contact with the child being continued, it's difficult for it to go on while he's in custody. And I understand why that would be, because it might adversely affect the child. But hopefully one day, real soon, he'll be out and in a position, depending on how the court rules, of course, to be in that child's life. He, of course, testified to what his plans were, but the trial court believed that that was speculative. He had testified.
I mean, what do you say about that? The fact that he hoped he would be out in a shorter period of time, but he really presented no proof that that was going to happen, did he?
He didn't.
Probably found it was speculation on his part and hope.
Exactly. And it is, I guess, to a certain degree, you can make that point. I would contend, though, that it was reasonable to at trial to make that contention, and the court could treat that as not being speculative because of the fact that it was stated as one of the conditions in his guilty plea or his finding of guilt that he would be eligible for early release. So that was reasonable, I think, for the court not to just treat that as speculative. That would be my response to that. I may have argued that at trial. I can't remember. I do remember that thought occurring to me. But in any event, that would be the response that I would have to that point. The trial court did make that point that they thought it was speculative. I see my time is winding down.
You have your time for rebuttal.
Okay, thank you, Your Honor.
We'll hear from the appellee. Nick,
Randy, his mic's off.
yes,
There you go.
Mistake number one. Hopefully
that's
not.
all right.
All right. Good morning. I'm Randy Sellers of the Bradley County Bar. Obviously, I represent the appellee's mother and stepfather. This case had one grounds in it, which was conceded as mentioned, but like many cases, the consequences that are implicit in this particular ground also weigh heavily upon the best interest of the child. Jackson D was born in 2013, and it's important for me to establish a timeline so we can see what relationship Dad did have before he went into jail. So child was born in 2013. The parties divorced, mom and dad divorced in 2014. And this was as a result of Dad being arrested in North Carolina on these two felony offenses of sex with a student. And I think the testimony was he was 31 and the woman was 17. That conviction took place in December of 15. And so this fella was already in jail at that point in time. And so Jackson would have been about 2.5 years old at that point. Before he was convicted of the North Carolina offense, he did take care of his son up to approximately 9 months because of the arrest. He lost his job and mother was working, so he would take care of the child. That's the only proof you're going to see in the record of the time frame that Dad had a meaningful relationship with the child. He would say he would take him to the park and things like that. The next thing that happened in sequence here is that in 2018, Dad is arrested and convicted in Georgia of computer pornography, and that is the basis for the grounds in this case. His sentence was it reads that it was for 20 years, 12 to serve, and 8 probation. He was also to register as a sex offender in Georgia. And by the way, he was required to register as a sex offender in North Carolina as well for 30 years. So as you might imagine, those two convictions and the judgment calls Dad made to get him to those points weighed heavily on best interest, not just grounds. So what happened next after this conviction in 18 for computer pornography, and that's the case he's currently in prison on. Mom filed this petition, mom and stepfather filed a petition for termination on that grounds. We did allege other grounds. We did non-suit those at the time because basically he was in jail, could not visit, like he might have wanted to, and could not support. So that left the one grounds that was conceded. We had our trial in April of 19. So Jackson was 5 at the time of the trial. So that's basically the historical background. So next, what are the relevant factual bases that the chancellor relied upon to find that it was in the best interest of the child for Dad's rights to be terminated? Number one, the fact that Dad had been in jail since the child was 3 years old, and the child's now 7, by the way, as we sit here today, was 5 at the time of trial. 2, poor judgment on father's part by bringing, and this was in the record, bringing a student, the student that he had sex with, and I believe that he had sex with her at the house while mom and child were there. Number 3, the fact that really no proof that Dad had a bond with the child other than him saying that he took care of the child by default for the 9-month period after he lost his job before the North Carolina conviction. 4, the fact that Dad admits he's had no counseling, no therapy, no mental health help while in prison and noted untreated depression. The fact that the child could suffer, and dad admitted this, a stigma from being the child of a sex offender. And that stigma could include anything from bullying to shunning the child or whatever. The fact that the child did not remember dad, the fact that during the 6 months of the Skype visits, that near to those visits, when they would happen, the child would soil his pants, and that would go on for a couple of days until after the Skype event. Also during that time, the child would get up in the middle of the night and just go in his mom's bedroom to see if she was still there. The fact that he was very introverted during that time. Conversely, at the time of trial, mom testified that he's now outgoing. He talks to anyone. He likes to pick up bugs. He's basically an extrovert. The fact that he's now in a strong, healthy parental unit with mom and stepfather, who, by the way, the chancellor noted, have removed the child from the situation that father put them in. The fact that stepfather has a bond with him and is now, quote, dad to Jackson. The big factor that as to best interest, that stepfather has taken care of the financial void that father left the child in. Another big factor that I think the chancellor relied upon, the fact that dad will never be able to participate in any event with his child where other children are present. And dad himself admitted that was not in the child's best interest. He admitted that on cross-examination. So what's basically the relevant law that the court should deal with? Obviously, there's the well-known case of N. Ray Audrey S. Standing for the proposition that when the interest of the parent and the child conflicts, the courts are to resolve the conflict in favor of the child. Also, and I've cited these in my brief, White versus Moody. This was very important, that the best interest test is viewed from the child's perspective, not the parents. And then also the factors that Mr. Armstrong mentioned as well in TCA 36-113I, I think there's 9 of them. The Audrey S. and Moody case both talk about that it's not necessary to tip a number of factors in one parent or the other's favor to decide the case, but that the relevancy and weight of each factor depends upon the circumstances of each case. And that the consideration of one factor, matter of fact, may very well dictate the outcome of the case. And again, that's from N. Ray Audrey S. as well. I have to give credit to the guardian ad litem, Sally Love, at trial, who argued the following, and it stuck with me since then. She said that the father has been reckless in his choices. He has destroyed his life, his marriage, and the damage permeates into his child's life. The child is now in a warm, loving family and does not or will not suffer the stigma of a sex offender as a father. She also said, the child shouldn't be required to sit on a shelf like a bowling ball. Again, it was speculative as to when dad will be out. So I thought that was a very poignant argument. The chancellor found that the two different, and she said this in her bench ruling, the two different convictions are crimes that show evidence of extremely poor decision-making with extremely high consequences. And from the child's perspective, I would argue that if the father's out, I've mentioned this before in the factual bases, he can never be around other children. So I might query the court to say, should the father, for his best interest, be allowed to be with his child in a bubble, given these restrictions? You can imagine all the events that a child could attend where there's other children present, whether it's a baptism, a field trip, a ball game. The child might be participating in the ball game. Child looks up in the crowd or in the audience to see his dad. Dad's not there. But who is there is mom and stepdad. And again, lastly, I do reiterate the stigma that could be associated with a child who it's found out potentially that his father's a sex offender. We all know how easily it is to go on a federal database to determine if there are any sex offenders in your area. If that got out to other children, the consequences could be devastating. The chancellor made specific findings in her ruling, and I've recited them verbatim in my brief, and it's 4 pages long. Several findings on best interest. But the one I want to point to, it's on page 20 of my brief, is item Q, And the chancellor even quoted a case or cited a case in making this ruling. She said, "In re LSS," it's a 2007 Tennessee appeals case, Lexus 597. And she looked at that case and compared it to the case at bar in saying that there's no evidence here that the child knows the dad, that the child has a relationship with the dad, that the child would miss the dad, and even after release, at whatever time, that the child can't be around other children. It would be still be several months or longer, even on his estimate, up to a year before he could assume responsibility for his child. So with that said, I believe that the best interest test has been proven by clear and convincing evidence. I believe the chancellor was correct in her ruling, and I would ask this honorable court to affirm her decision. Thank you.
Thank you. We'll hear from the appellate in rebuttal.
Thank you, Your Honor. Just to correct something that Mr. Sellers said, I think he argued earlier about one of the offenses that my client committed regarding the underage student happened while the mother and the child were in the home. It did happen in the home, but I believe, in fact, the mother and the child were not there when it occurred. I would also mention as well, but the thought occurred to me that in his convictions, there was no restriction on him being around his own son. It is true, of course, that he would have to register, I think it's for a period of 30 years with the sex offenders registry, if I'm not mistaken. And that's conceded. That point is conceded there. But in taking all of the factors before the court, again, I think the proof shows that there was a strong relationship between this father and this child, and the child.
Counsel, let me interrupt you a second.
Yes, Your Honor.
Your client went to jail in North Carolina, or
Georgia.
How old was the child then?
He was about 2 years of age, if I remember correctly, Your Honor.
And how old was the child when the parties divorced?
He would have been a little over, but somewhere between 2 and 3, if I'm not mistaken. I think it was an uncontested divorce.
All right. Okay, go ahead.
He was young. Before that happened, though, as Mr. Sellers was talking about, he would be involved with the child because he was off work. He had lost his job as a result of what he did, and it was poor judgment on his part. But I believe there is proof in the record that would indicate that he has made a very strong effort to rehabilitate himself, contrary to what counsel was arguing earlier. And he has taken steps to try to fortify himself against anything happening in the future where he would make these poor decisions ever again. Again, the thing that he wants to reiterate is that he is completely content, as was evidenced by the letter that he sent to both Mr. and Miss Moss, content with the fact that they are very good people and that they have nothing but his son's best interest involved. He just wants to be a part of the child's life and just does not want to have his parental rights terminated. This was something that he reiterated when he sent that letter to them. It was really more of a plea than it was anything else. It really was. I believe that's all that I have in rebuttal.
All right.
Unless the court has any questions.
I hear none. Thanks to counsel for both sides. Mr. Hevner, if you would, please, you'd recess court till 1:30 this afternoon.
This honorable court is now in recess until 1:30 p.m.